Imagine being on trial for murder and hearing your own lawyer stand in front of the jury and say, "My client did it." But there's one huge problem. You told your lawyer not to say that because you insist you're innocent. That is essentially what happened in McCoy v. Louisiana, a 2018 U.S. Supreme Court case about the Sixth Amendment right to counsel. Robert McCoy was charged in Louisiana with 3 counts of first-degree murder involving members of his estranged wife's family. McCoy repeatedly maintained that he was innocent and pleaded not guilty. His attorney, Larry English, looked at the evidence and believed the prosecution had a very strong case. So the attorney came up with a strategy. Instead of trying to convince the jury that McCoy didn't commit the killings, he wanted to concede that McCoy was the killer and focus on convincing the jury that McCoy lacked the mental state required for first-degree murder. The goal was to avoid a death sentence, but McCoy strongly objected. He told his attorney that he wanted to maintain his innocence. He even tried to fire him before trial, but the judge would not allow the change at that point. Despite McCoy's objections, his attorney told the jury that McCoy had committed the murders. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. McCoy then took the witness stand himself and continued to insist that he was innocent. The jury convicted him of all 3 counts of first-degree murder and recommended the death penalty. McCoy appealed. The case eventually reached the United States Supreme Court, which faced a very important question. Can a defense attorney admit that a client committed a crime when the client specifically tells the attorney not to? In 2018, the Supreme Court ruled 6-3 in favor of McCoy. The court explained that lawyers are allowed to make many strategic decisions during a trial, things like which witnesses to call, which questions to ask, and which objections to make. But some decisions belong to the defendant personally. One of those decisions is whether to maintain innocence. The court said the Sixth Amendment gives a defendant the right to decide the fundamental objective of his own defense. So even if the attorney believes admitting guilt is the smartest strategy, the attorney cannot override a client who clearly insists on maintaining innocence. Because McCoy's right to control that decision had been violated, the Supreme Court reversed the Louisiana Supreme Court's judgment and sent the case back for further proceedings. So the lesson from McCoy versus Louisiana is simple. Your lawyer may be the legal expert, but you are still the defendant. And when it comes to the fundamental decision of whether to say, "I'm guilty" or "I'm innocent," that choice belongs to you. Thank you for watching. If you enjoyed this story, watch this case next.